everyone. How are you doing? Hope you're good. Hope you're fine. You're welcome to Lawyers Info Hub. It's always a pleasure to create content on this platform. I remain your host, Mercy. Yes, you're all welcome. If you're yet to subscribe to the channel, please do hit the subscribe button. Share the video, drop your comments. I love to see your comments. I love to see what you think. For my returning subscribers, I appreciate you. Thank you for always stopping by here to know what is new on the channel. I really, 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 really appreciate you. So today, upon enormous request. Yes, a lot of people have asked me do this video. Yeah, how to answer legal questions. This is for law students. I believe in the law students. I believe in the younger generation. I believe that if we give the right um, strength or the right energy towards our students, will build good lawyers. Lawyers are not being built at the law school. No, lawyers, you groom them, you build them in the university because they have a longer time to stay in the university. And so you have so much time to build them, groom them. I thank you for those who are already joining or who are already joined or connected to this live video. Thank you very much. Now let's hit it at it is how to answer legal questions. As a law student, being able to convince your lecturer, being able to convince your professor, being able to convince your teacher that they have learned what they have taught you, or that you can put your mind into the questions being put to you, shows that you're growing or that you're a good student. Sometimes when you're being taught, it takes further study for you to really understand the dynamics of what they have taught you. Sometimes it takes personal effort for you to know, how do I approach these questions. Sometimes you're just being taught the theory, and by the time questions are now being, you know, put together for you to now bring out the legal knowledge, is difficult for you. It's difficult for you because you don't know the right approach. It's very easy to answer legal questions. Yes, it's very, 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 very easy. Now, until you get the right formula, you might be having difficulty in attempting your legal questions. For some schools, which I know most schools do essays in terms of theory questions, not like multiple choice. Why by some schools, depending on your level, they do multiple choice questions. But you know what? When theoretical questions, well, questions that involve you writing, when it is being used, if it's the format your school is using, it helps you because it helps your mind to think. It helps you to be on your toes. You not place yourself in that situation like, what if I'm now a lawyer? How do I handle these issues of my client? So whenever you see a question, assume you're already a lawyer and that you're not being consulted to provide solutions to the problems. Now, the normal old rule or the old format IRAC is still what is obtainable, whereby there have been other new modern ways you can answer the legal question, but it's just the acronym IRAC. But you see that even the new methods that have been used now, it still revolves around the structure of IRAC. What is IRAC? IRAC. I stands for issue or introduction. R stands with the rule or the law. A stands for analysis or argument. And C stands for conclusion. When you're being given a question, for example, there's a question revolving about issue of a revocation of a statutory of a CFO, or issue of contract, and maybe a question, a fictitious or an imaginary scenario is created for you to understand. Maybe they're putting issues of the elements of contract in the question, and the question is being posed to you. Now, your lecturer is expecting that you begin to see the scenario as a life situation, being able to see whether there was even a contract from the scenario. Okay, if there's a contract, is there any element missing? Is, they'll ask you questions, to just open your mind up to know whether you even understand the concept. First of all, you know that every question is tied to, let me it's tied to a topic in your book or in your textbook. Yes, for example, when you're talking about, I will still use contract because it's more relatable. In when you're in your law of contract, they'll teach you formation of contract, elements of contract, types of contract, this and that. So when you see questions surrounding contract, what your mind should raise back to is, when I was taught contracts, what did my lecturer say? So beyond the question being asked, what your lecturer is looking at is for you to understand whether you've gotten the rudiments of the knowledge sought, they desire you to have in understanding what contract is all about. Now, in Iraq, I told you is introduction or the issue. Now you have been asked your question. You have to just translate or summarize your question in an introductory manner. Do a proper introduction. A proper introduction aids the lecturer, aids the examiner to, it engages the examiner. If your introduction is very poor, it will piss off, or it will not make the examiner look long for what you have in your book or in your exam booklet. Always have a catchy introduction. Understand what the question is all about and give a proper, introduction. When you give a proper introduction, it links the other things you want to write. But when your introduction is shabby, when your introduction is just anyhow, it gives the examiner like this person doesn't even understand, because the introduction is what tells the examiner whether you're on point or you're out of point. Your introduction is what tells the examiner that this person even understands what the question is all about. So have a beautiful introduction. In your introduction, let the examiner know what the issue is all about. Now, R stands for rule, or what the law says. In every question, there must be what the law says. Yeah. I appreciate it when you see law students who cite cases. It's very beautiful. But peradventure, you don't have any case to cite. There must be what the law says in terms of, okay, in contract, this and this must be present before I can say there is a contract. Now, that is not what you put in that rule or the law. You say, there to be a contract, these elements must coexist. State out intention, all of that consideration, all of that, you state it out. Your examiner will know that this one understands this question. Now, what is now the argument or the analysis? This is where the core of your answer is. This is now where you now relate what you know about contract, which is the question they have asked you. This is where you now interpret the law. For example, you have a case on a matter with respect to your question. This is now where you apply the law to the question. This is where you now answer what the question is. They're asking you something. This is now where you bring out the answer in your analysis. So you've done a beautiful introduction. You've done your rule or the law. That is where what is the law regarding the question they have asked you? You bring out the law. Then the analysis is when you now bring the law together with juxtaposing it with the question they have asked you. You now, write it out. Then you make your conclusion. Is that simple? Yes, very simple. See, if you use this format, you end up having a very good mark, because your introduction can even sweep the examiner off his feet. Like, what? This person understands what are being asked. Then your rule, which is setting out what is the law behind the question, what is that issue, what is that law guiding this question. If you're able to write it out, the examiner will know that this one understands the law. Then when you now juxtapose the question with the law, that is where it is in your analysis or your argument. It is a superb for you. Then your conclusion. What is your conclusion? Being able to, you've analyzed it. Then what is your conclusion? By saying that peradventure Mr. A having not the contract between Mr. A and Mr. B has not crystallized because still an intention maybe to enter into contract. Or what is that the conclusion? Your conclusion will give juice to your answer in your analysis. Yes. Your conclusion should be on point. Your examiner should not be reading so much to know what you are concluding. Your conclusion should be short and straight. It must be straight to point. Yes, your conclusion and introduction, very key things. Your introduction must be catchy. Your introduction must go straight to the point. Your introduction should not be too long. It should not go off the track. It should center around the questions you're being asked. Your rule, very important. There must be a rule surrounding, there must be something very spectacular in that question that you have been taught. Maybe the issue of defamation, you have taught different things. Now, what is the law guiding that question, that particular topic? You write it out, then your analysis is superb. You analyze, bringing your question together with what the law says, and synchronizing it for the examiner to know that this one understands the question, this one, yes, understands the question. Maybe for you to now say, there is a missing ingredient here, and because it's not there, this cannot happen. It gives your examiner that idea. Now, for example, you have cases to write. That is under your argument. This is why you now put down your cases. Where you don't have cases, but as a law student, it's good for you to know cases. Very important. I encourage law students to visit a library. Even when you don't have a good library in your school, there are online legal resources. There are online libraries you can access and get more knowledge beyond what you're being taught in class, beyond what you're being taught by your lecturer. It gives you that broader understanding of what that concept is all about. Then your conclusion should be on point, should not be too much. It should be just straight to the point. And it should be able to, when your examiner reads your conclusion, feel of the truth, this one knows what he or she is doing. When you arrange your work this way, there's no way you go offline. But when you don't have this idea of format, you end up putting the major answer inside your long, maybe 3-page work, where your examiner may not have the patience to read the substance of what you're writing. Introduction, your issue, your rule, what's the law saying, what's the analysis, what's the argument, and what's the conclusion. If for every question you're being asked, try not to be verbose in your argument. Some people have big handwriting, fine, but your questions should not be more than 1.5 pages or 2 pages max, depending on your size, the size of your handwriting. When your work is too verbose, and your examiner is not a patient person, you might not be able to read everything. This is just a secret why many people fail. Not like they did not write, they are writing so much, I don't know, the art of point. Let your thoughts flow. If you write what you're writing making sense and 2 pages, your examiner will be willing to. But when what you're not following the format and what you're writing is off point, your examiner may not be patient enough to even read to the point where you're making sense. So be very careful when you're writing your exam. Don't you want to collect extra sheets to who are you impressing? Don't impress anybody. Rather, impress yourself if you want to impress somebody. Yes, yourself first before anybody, but write something reasonable so that your examiner can be excited to even uh, read your answer sheet. Another problem many students have is the legibility of your handwriting. If you don't have a good handwriting, try and work on it. You see something, some people have the knowledge, but the handwriting is so bad that it does not allow the examiner even understand what you're writing. Work on your handwriting. Lawyers are meant to have good handwriting. Work on your handwriting. Very important. Many people have failed the law school because of bad handwriting. Work on your handwriting. Very important. Work on your spelling. Arrange your work sequence very beautiful. Let it have a layout. Once your work has a layout, it makes it very easy. So legal questions are very, 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 very easy. The only thing that, do you understand the concept behind the question? Do you understand the answer? Yes. Do you understand the answer? Some people will just write five lines as answer, but sometimes and you just go straight to the point. Fine, you want to go straight to the point, but you should have this format. Bring out do a little introduction, write out the rule, what is the law or the rule or the law, what is the argument, what is the conclusion. Beautiful. You see that you end up having great marks, improving your grades. Yes, as a student, you don't have that latitude to fail, because here I believe in excellence. I'm an excellent student. When I was a student, I'm still a student though. um I believe in excellence in all I do. Yeah. So give it your best, because this is the best time you can ever be a student. Thank you very much. Hope you enjoyed this class, and do take care of yourself. Bye.